Deep Conversations with KK on Akosuah Ann. So the channel is Akosuah Ann. You can just subscribe. We're talking about copyright. We're talking about intellectual property, IP. That is IP. But let's first take what we call the copyright notice. So when we talk of copyright notice, is a statement that indicates a work, such as literature. You can talk of music or film. That is what's being protected by copyright laws. So the notice that you get includes the copyright symbol. That is the C in a circle. That is the copyright symbol. Then the year of publication. If it was published in 2020, you see the date there, the year 2020 there, and then the name of the copyright owner. If whoever owns that intellectual property's name must appear. So if it is John Doe, it will be like a C in a circle, and then the date 2024, John Doe as the intellectual property owner or the copyright owner. Understood? So now let's look at the purpose of the copyright or copyright notice. The purpose is to inform others that the work is what being protected. Every work that you see, whether it is artistic, literary, music, film, it has owners, and then it has been what? Registered or licensed. So before you use any part of it, you need to get attributions of what we call the permission. So whenever we do the copyright notice, it is to tell people that the work is what's being protected too. It provides notice of who to contact to seek permission or to get attribution. If you want to attribute the work to the owner or the rightful owner, you need to first contact the person. So to contact the person, you need to get the copyright notice. That will let you know whom to contact. And then the third one, it helps you establish a proof of ownership. In any case, if there is any infringement, if somebody uses your work and the person, if it is not a fair use, we have fair use, we have what we call the fair use. If it is not a fair use and there is any infringement, the copyright notice will help you to establish a proof of ownership that the work is yours, the work has been registered, whether it's a trademark, a copyright, a patent. So anything artistic, literary, music, film, book, novel, anything that you can mention, it is all what's being protected. But one thing that we should take notice, copyright laws vary by country. Copyright laws vary by country. So the copyright laws of Ghana might be different from Nigeria, so as it might be different from Niger, from Cote d'Ivoire, as like that. And we have what we call the intellectual property, IP, which refers to the legal rights that protects creations of the mind, such as inventions, processes, literary work, artistic works, designs, and symbols. So the symbols, when you talk about the symbols, you can mention something like that, Dinkra symbols, Jinyame, a lot, Uwachi and those things. So those are symbols. We have signs, we have symbols, we have names and images used in commerce. Commerce is simply the activity that embraces all forms of purchase and sale, that is of goods and services between people, organizations, or entities. That is what commerce. So any of these things that is used in commerce is what called an intellectual property. Any legal rights that protect the creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. And I mentioned that commerce is the activity embracing all forms of the purchase and sale of goods and services between people, organizations, and entities. We have types of IP. The IP is what? The intellectual property. We have types of intellectual property rights. Number one is patents. But normally, you see, we mostly talk about the copyright. We mostly talk about the copyright, leaving patent, trademark, and then trade secret aside, because normally these are, copyright is mostly infringed. Copyright is mostly infringed. So let's look at the types of intellectual property rights. We have the patents. The patents usually protect inventions like new ideas, new methods of doing things, processes, machines. So if somebody invents a machine, you have to know that that machine in particular is being protected. So you cannot also bring something of that sort unless it is fair use, or you are taking, a smaller part of it to reinvent. So aside that, that is what trademark protects any invention that you can mention, any invention that you can talk about, any innovation, any processes, any methods, machines, and whatever that you can mention. And then the second one is copyright. So copyright protects original literary, dramatic, musical, and artistic works such as books, music, film. So that is where mostly the noise is. That is where mostly the noise is, because you hear that somebody would take an element in someone's song. Like just recently, Gamanche, Nimanche versus Obrafo. Nimanche versus Obrafo. So I think he took part, a sound in the song, and that is what copyright. Anything that is not yours, or if it has been registered, if you want to take part of it, to do anything, if you want to redo it or whatever, you have to get attribution. Either you attribute it to the person, or you seek permission before using any part of it. Whether it's a film, it's a book, it's a music, you need to get permission before you use it. And then we have the trademark. So the trademark, it protects distinctive signs and symbols. Like I mentioned earlier, the Adinkra symbols, Jinyame, the Owache there. But it's quite unfortunate that in our part of the country or in our part of the world, symbols are somehow neglected, because people use these symbols regardless of who owns it. People just use it. It's not just fair use. This is not fair use. People use people's symbols just like that, because mostly what we experience is that they are not often registered, or people don't own the rights. That is why we often use some symbols without any consent, or without the rightful owner's consent. But in any case, if it is registered or licensed under the copyright laws or acts, you need to get permission before you can use any of it. Names, logo, any logo that has been used by a business, a product, any name that has been used by a product or a business, an organization, you cannot take any part of it. Something like Adonko, you cannot use Adonko because it is for ABN, it is for Dr. Kwakuoten, it's for him, it has been registered. So before you can use any part of it to do any other thing that will get you money, or in commercially using it, you need to get permission before you can use it. We also have the trade secret. The trade secret, it protects confidential and valuable information such as business methods, recipes. So for the chefs, those who do the cooking and those stuff, I mean, if you have any recipe, it is your idea, is your method of doing it. So you have the right to protect it. You have the right to keep it a secret. If anybody wants it, the person has to seek permission from you before they can take part of it. And then we have the industrial design. Industrial design, they are also part of the types of intellectual property rights. And let's look at the benefits. We have the exclusive use. So the exclusive use is that it gives you the rightful owner, it gives you what we call an exclusive use to your work. So you can use your work anyhow you want it. And then also it prevents other people from using it, copying it, or distributing it without your permission. Nobody can use your work without your permission. Copying it or distributing it, you can't do that without the rightful owner's permission. It gives also financial benefits. That's benefits. You enjoy royalties, you enjoy from sales, you get royalties from backends. So in music, like music, when you distribute or publish your songs on these digital streaming platforms, you get what you call the back end. That is the royalties you enjoy from what you have created. The song, you are the rightful owner to it. So any royalty that is coming from it, you have to enjoy it. And then protection from theft. Protection from theft. So intellectual property rights protect legal records for creators whose work has been stolen or has been used. I will give you an example. So if you remember this animation, this movie, The Lion King. The Lion King. So The Lion King is it had a controversy. It had a controversy, and the controversy was alleged by a Japanese movie. Yes, a Japanese movie that was released in 1998. So the title was Kimba the White Lion. Kimba the White Lion. So the people were alleging that those who brought the Lion King, they took part of the Kimba, the White Lion. They took part of it to do that movie. The similarities and everything, the characters, the names, everything, they copied everything. So I think it was something that they were fighting on. Even whilst we were watching the Lion King on the screens, they were also talking about the copyright infringement. So when somebody takes or steals a work from the rightful owner, that is what we call the plagiarism. Plagiarism, which is the act of using someone else's words, ideas, or intellectual property without proper attribution. And then you effectively present it as yours. So, in other words, you did not seek for permission, but you have also presented it to the masses or to the people or your audience as what? As your own. That is what? Plagiarism. And I mean, it is considered a very serious ethical and legal violation. If you do that, anybody can take you to court. Anybody that is serious, who knows their laws, will take you to court. So we need to take very conscious effort to, learn these rights, these copyrights. Usually those who are creators, the creators, whether it is an idea, a method, or whatever, you need to make sure that you have licensed it. If you licensed it, nobody can take part of it. If somebody wants to use it, the person has to seek what? Permission from you before they can use it. So the next thing that we will talk about is the fair use, but that will be next week or the next episode on fair use. But when you come to Ghana, we have the intellectual property rights, and they are protected by laws. So the laws that we have the Copyright Act 2005, which is Act 690. Act 690, Copyright Act 2005, Act 690. And then we have the Patents Act 1992, which is PNDC Law 305A. Patent Act 1992, PNDC Law 305A. And then we have the Trademarks Act 2004. Trademarks Act 2004, Act 664. So you can check it from Google, and then you know how to protect your works. You know how to go about when somebody steal or misuse your work, where to go. If you know these things, there is no way anybody can infringe on your rights. If you are the rightful owner, make sure that you have the licenses. Make sure that you publish it, especially the musicians. Make sure that you publish your songs. The artists, make sure that you have licensed your works. Any artistic or literary work that you do, make sure that you license it, so that if anybody has to take a part of it, it will only be a fair use. But if it is stolen or misused, then it means you have the right to fight for it, because you are the rightful owner. So this is the end of the episode, and the next episode will come on fair use.